I'm Joe Butler of the Butler Law Firm, and today we will talk about joint and several liability versus apportionment. Joint and several liability is the way things worked in the state of Georgia for decades and decades and probably centuries, and the way things worked for a long, long time, going back to ancient England, what lawyers call at common law. Joint and several liability was usually the rule. And here's what that means. When one person, say an injured person, who's the plaintiff, files a case against two or more other people or entities, that is, the plaintiff files a case against at least two defendants, a question arises of which defendant has to pay. So let's say that plaintiff suffers damages in the amount of $1 million. It's a significant injury, and the court determines that the plaintiff is entitled to collect $1 million. The question is, from which defendant can the plaintiff collect that? Under the joint and several liability rules, the plaintiff could collect that million from either. The plaintiff got to pick and could collect that full $1 million that the plaintiff was due from either defendant. And then the defendants could fight among themselves. If plaintiff collected that amount from D1, then D1 might sue D2 and say, hey, you have to chip in. If plaintiff collected it from D2, then D2 had the right to sue D1 and say, hey, you have to chip in. That was joint and several liability, and it was the law of the state until 2005. In 2005, the legislature passed a new rule, and this rule is called apportionment, and it took effect a little bit after it was passed. It changed the rules in a fundamental way. Now, if the injured person, the plaintiff, sued D1 and sues D2, then the jury or the fact finder determines what percentage each defendant has to pay. So if the case goes to trial, the jury would write on a verdict form. And the verdict form, that is the piece of paper on which they write their decision down, would have something that looks like this here: a percentage for D1 and a percentage for D2. And the jury could write in there sort of whatever they deem fit. They might think that the first defendant is 70% at fault and the second is 30% at fault. And in general, each defendant has to pay whatever their apportioned share of the damages are. And you can find all that in OCGA, that is the official code of Georgia annotated, section 51-12-33, which will come up on Google if you'd like to look at it.